what they are essentially is a legal opinion on the constitutionality of Bill 13. They identify 6 potential sections of Bill 13 which are problematic from a constitutional point of view. The general format of the written submissions is first the identification of the problematic section. Secondly, an explanation of the concern of that section. Third, an overview, a brief overview of the relevant law. And then fourth, and finally, a proposed amendment. Attached to Schedule B of the written submissions is a version of Bill 13 which reflects the proposed amendments. So what I'm going to do now is attempt to very quickly and briefly set out the sections that the Coalition finds to be constitutionally problematic and which will eventually lead to years of taxpayer-funded litigation. First is the preamble. The 5th paragraph of the preamble singles out one group of children who identify as members of the LGBTQIA community. As previously stated, the Coalition believes that any form of bullying is reprehensible, and it holds that the province legislating preferential concern of one group over another is also problematic in practice, in policy, and in law. Such preferential treatment violates Section 15 of the Charter and potentially violates Section 2A and 2B of the Charter. The Coalition proposes that by simply removing the words including LGBTQIA people with special status and priority treatment or protection rather, one group over the others is eliminated, thereby making Bill 13 equally protective of all groups and all individuals, and therefore more inclusive. On a similar note, paragraph 6 of the preamble states that everyone has a role to play in preventing incidents based on homophobia. The term homophobia is also used in Articles 4 and 7.2 of Bill 13, and is problematic because it has yet to be treated jurisprudentially or legislatively defined. It's a subjective term and it's a controversial term and should therefore be removed. Secondly, Section 1, which deals with the definition of bullying. The definition of bullying found in Bill 13 is very, very subjective, and it is its subjective nature which is problematic because any type of behavior could be found to fit that definition. The definition of Bill 13 removes intent as a necessary component of the Act, which is irregular and contrary to most forms of legislation, including criminal legislation. Another difficulty with the definition is the question of who will be the subjective arbiter of what behavior meets that criteria and is or is not bullying. Again, this is too subjective to be properly interpreted and applied. As a proposed amendment, the Coalition proposes that this committee replace the definition of bullying in Bill 13 with the definition found in Bill 14, which accomplishes the goal of setting a clear and intelligible definition of bullying without the difficulties associated with wording in Bill 13. Thirdly, Section 2, which deals with equity policies. This section gives the Minister of Education authority to require and direct all school boards to implement changes to their respective equity policies. This section is redundant. Public policy memorandums number 119 and 144 already require all school boards in Ontario to prepare and implement equity policies. Effective equity policies are specifically tailored to the unique state makeup of the students of each school, and the development of the equity policy must remain the responsibility of the individual school boards who possess the facts and the knowledge required to properly address the issues faced by the student body in their respective districts. Now, in addition, with Ontario's separate school system and our school board system, we have to give consideration to the denominational rights of Catholic school boards. Ontario students have a legal right to a taxpayer-funded education that is either non-religious or Catholic. Nobody has the right to insist that Catholic schools and Catholic policies become non-religious or non-Catholic. The Coalition proposes that by removing Section 2, this learning committee would accomplish the goal of ensuring that each school board maintains an equity policy because it is already mandated by PPM 119 and 144, while ensuring that the school boards have the ability to develop an equity policy which is designed to reflect and address the issues faced by their respective school bodies. Additionally, this committee would ensure that the denominational rights enshrined by the Constitution of the Catholic school boards are respected. Fourthly, are Sections 7.1 and 7.2 of the bill, which deal with third-party use of schools. These sections require school boards to rent school facilities to third parties to include an agreement requiring the third party to adhere to the provincial code of conduct. The bill in a different section also has a provincial code of conduct to reflect the definition of bullying as found in the bill. Many faith-based groups, political organizations, and churches rely on the uses of schools, renting facilities to host meetings and worship. These sections have the potential, in their effect, of preventing these faith-based groups, political organizations, and churches from continuing to do so. These sections have the potential effect of violating Section 15 of the Charter, as well as the freedom of religion of these faith-based schools and churches, and potentially even their freedom of assembly. By removing these sections, the bill's constitutionality could be preserved and the purpose of the bill is not compromised. This section does not address bullying. It has no place in anti-bullying legislation. Fifthly, Section 9, which deals with board-endorsed clubs. This section of Bill 13 singles out 4 specific types of activities or organizations, but it fails to address many other potential activities or organizations which could and would be beneficial. Section 9 fails to consider the existence of other occurrences of bullying, which happen statistically at a much higher frequency than the bullying on the basis of the characteristics set out in Section 9. The most controversial with this section has been the mandating of GSAs in all schools. By mandating GSAs in all schools, this section violates the freedom of religion, conscience, and association, potentially even the freedom of expression rights of many students and parents and teachers. It is also a clear and direct violation and infringement on constitutionally guaranteed denominational rights of Catholic school boards. Any interference with the denominational rights, religious autonomy of Catholic school boards would be a clear violation of Section 931 of the Constitution, as well as Section 257, sub 52 of the Education Act, and potentially Section 29 of the Charter. The Coalition proposes that Section 9 of Bill 13 should either be removed or amended to include all groups who are bullied at much higher frequency. Sixth and finally is the issue of private schools. Bill 13 makes no reference to private schools, and there does remain some uncertainty as to whether or not Bill 13 will apply to private schools. This committee can alleviate any concern or ambiguity by simply specifying in the preamble of Bill 13 that it is not intended to affect the ability of private schools to determine their operations, their management, or their curriculum. Now, to summarize, Bill 13 does contain a number of provisions which are likely to be challenged on a constitutional ground. Its main problem is preferential status it gives to one specific group to the potential detriment of other groups. By removing the preferential status of that one group, Bill 13 avoids most of its potential constitutional challenges, becomes more inclusive, and continues to address the problem of bullying for all reasons. So those are my submissions, of course, subject to the written submissions before you, and I'd be happy to entertain any questions.
Thank you very much for your presentation. We do have about 1 minute left on the questions of the third party.
Yeah, thank you, Mr. Chair. Sir, thank you for coming down this morning and making your presentations. Do you see that in the section that provides for clubs to deal with racism and sexism, to deal with attacks on the disabled and the educated, that there's an exclusion for other clubs from being formed?
Well, I don't see in Bill 13 a prohibition from other clubs being formed. But it's the fact that the bill specifies 4 groups and mandates the clubs, those clubs, I guess I would say, while not mandating the others. So what it does, its effect, maybe it's not its intent and maybe it's an unintended consequence, but the effect of the mandating 4 specific groups and not the others is that it gives preferential treatment or priority status to those groups, with the potential detriment of the others.
And here in Ontario, the Ontario Human Rights Commission and Human Rights Code, we specify groups that tend to, more often than others, be subjected to negative treatment. And I'd argue that similarly in Bill 13, we specify groups that, just as we find under the Human Rights Code, people who tend more often than not be treated unfairly. Do you see no analogy between the two?
Well, what I see is that the Bill 13 in this particular section creates 4 groups, but the largest reason for bullying is body image, and yet there's no group to promote awareness of people who differ in terms of body image. Now, to address the issue of the Human Rights Code, as does the Education Act,